Our last case for today is People versus Washington. This is a 20-minute grant with an additional 5 minutes for amici.
Good afternoon, Chief Justice and Justices. May it please the Court, Melissa Keys on behalf of the people of the state of Michigan. I would like to reserve 3 minutes for rebuttal and will keep my own time. In 1996, this Court reaffirmed the common law corpus delicti requirement remained the rule of the state in People versus McMahon, a case involving the disappearance of Carolyn Kenyon. Mr. McMahon confessed to killing Ms. Kenyon and 2 others, but because Ms. Kenyon's body was never found, the majority of this court adhered to the rule that the body of the wrong, or the corpus delicti, must be shown in Michigan independent of any confession, and that the criminal agency for the reasonably presumed death of Ms. Kenyon could not be decided without the confession. In a dissent for 3 justices, Justice Boyle noted that the reasons and the means causing Carolyn Kenyon's death are not a mystery. The defendant killed her. In McMahon, there was a specific loss or injury involved, the death of Carolyn Kenyon. Where there is no specific loss or injury in a possessory crime, such as is the present one, which is only criminal because Mr. Washington had a prior conviction for an aggravated felony, the corpus delicti rule makes little sense. We urge this court to overrule McMahon, but at the least hold that the corpus delicti rule, whose origins are grounded in the 17th century murder cases without bodies, has no application here. This court has always said that the corpus delicti rule applies to confessions of guilt, not admissions of fact. Neither body armor nor the possession of body armor to which Mr. Washington admitted are crimes. Independent proof that the possessor had a prior conviction for a violent felony is required, and then the 2 are presented to the jury. The independent proof of the prior violent felony conviction is the reason why the corpus delicti rule does not apply here, and the defendant's admissions of fact made during the booking process while he was not being questioned, and to his mother during a voluntarily made phone call were powerful evidence of defendant's guilt. The Court of Appeals majority, however, erroneously expanded the corpus delicti rule, conflating admissions of fact with confessions of guilt in violation of People versus Porter and People versus Conrad. If this court decides or determines that the corpus delicti rule is inapplicable and reverses the lower court's decision on this basis, it need not reach the implied testimonial hearsay question. But if this court does, there is no escaping 2 points. Number 1, the United States Supreme Court has repeatedly said, in the end, the question is whether, in light of all of the circumstances, viewed objectively, the primary purpose of the conversation was to create an out-of-court substitute for trial testimony. And number 2, whatever the inference from what the Canadian officer said to the United States officer was not admitted for the truth of the matter asserted. Appellee says that the question and answer, quote, now, without saying anything about what was said, the only question I have for you is, were there communications between you and Officer Lavers? And on receiving an affirmative answer, asked, quote, and based on those communications, you took custody of the defendant, end quote, constitutes testimonial hearsay, meaning that whatever the Canadian officer said had as its primary purpose to create an out-of-court substitute for trial testimony, though the Canadian officer did not know that Mr. Washington had a prior criminal record what Michigan's prohibitions against body armor were, or even whether the Canadian government would end up not allowing him to testify. This is fanciful, as the notion that the inescapable inference from this conversation was that the Canadian officer said that the defendant possessed body armor rather than he was the one who jumped the toll. And in no case was any inference argued to the jury in any fashion. Specifically, the trial prosecutor fully acknowledging in his closing argument, quote, "I would agree with Mr. Politano that if the only evidence that the people had to present was the defendant being turned over by the border services from Canada not wearing body armor at the time, and that was it, nothing else, then you would not have enough to convict the defendant beyond a reasonable doubt, because there is just no factual connection. However, that is not the only evidence that the people presented. The people also presented two statements from the defendant," end quote. The jury could draw an inference that Mr. Washington possessed body armor from the fact that the Canadian authorities turned it, as well as the defendant and defendant's truck, over to the United States Customs and Border Protection's officers. It was not a birthday present, nor are there any locations between the United States and Canada where an individual may purchase body armor. But the powerful evidence of possession was Mr. Washington's statements, and the possession of it was shown independently by proving that the defendant had a prior conviction for a violent felony conviction. The Court of Appeals decision must be reversed. I welcome questions at any time. The people would note that the Court of Appeals majority identified what it believed to be the plain implication of the exchange between the trial prosecutor and Officer Stockwell without considering any other implication from what that communication was. Importantly, there was never an attempt to circumvent the confrontation clause, nor was there an attempt by the trial prosecutor to argue it in an improper way. And in fact, the prosecutor specifically told the jury not to consider or not to base a decision on guilt based on the exchange alone, because that would not be enough evidence. Also, juries routinely rely on circumstantial evidence to draw their own inferences, and likely drew many. If there is a concern regarding the potential prejudice that could result from a confrontation clause implication, then the remedy would be a limiting instruction. In this particular case, there was not a limiting instruction that was requested, but certainly a limiting instruction would have cured any kind of potential prejudice, advising the jury how it could consider that particular evidence. Notably, the majority omitted from its consideration any of the other facts surrounding the particular exchange, concluding that there was only one inference that could be drawn, and it was the inference that the Court of Appeals majority reached rather than the inference that was ever argued at the time of trial. There are a litany of cases where the contents of information were not offered to prove the truth of the matter asserted, but to explain why a detective did what he did, or to show the effect on the listener. People versus Chambers and People versus Putman are examples of those particular cases. The cases cited by appellee, the testifying witness relayed specific information provided by co-defendants, co-conspirators, or witnesses during interrogations accusing defendant of wrongdoing. In that way, these individuals were defendant's accusers. Here, the Canadian officer, when he turned over the defendant and the body armor and the truck, did not accuse the defendant of committing wrongdoing, because wearing body armor or possessing body armor is not illegal. Moreover, amicus Professor Friedman noted in his brief that he filed with this court that if the United States Officer Stockwell needed to explain his subsequent actions, and amicus does not believe it was, the fact that Washington was being delivered together with the body armor was sufficient. But there was no substantive difference between amicus's suggestion and the way that the prosecutor questioned the witness and argued the exchange at trial. It should be noted that one of the questions that was asked was, well, what was the reason then why the prosecutor asked that question in the first place? The fact that you turned over the defendant, you turned over the body armor and the truck at the same time, because the only inference that could be drawn was that the defendant was wearing it. But under Michigan Rule of Evidence 901, the people are required to lay a foundation for the admissibility of evidence. The people are required to authenticate that the item that was involved in a particular case is the item that it purports to be. So establishing that kind of chain of custody was important to establish between Officer Stockwell taking that item from the Canadian authorities at the same time that he took the defendant and the truck. Moreover, there is, I think, a misunderstanding about whether or not the defendant, once he was taken into custody, that Officer Stockwell started the charging process at that time. And that is simply not true. Officer Stockwell testified that as an American Border Service and Protection Officer, that it is his duty to inspect every single person that re-enters the United States to determine whether or not they're eligible to re-enter the United States. So the defendant would have been taken into custody one way or another. And whatever the defendant did in Canada, which was run away from the Canadian authorities and failed to stop at secondary, was obviously not something that the Canadian authorities were concerned about, because they returned the defendant and his truck within an hour of the defendant jumping the toll. The corpus delicti in this particular case, People versus Porter and People versus Conrad, to me, are directly on point. The majority in this case cited People versus Porter and People versus McMahon, which do not involve possession case or did not involve possessory crimes, whereas People versus Conrad did. In People versus Conrad, this court stated that proof of identity of the perpetrator of the act or the crime is not part of the corpus delicti. The fact that the defendant made statements to booking officers, absent questioning, this was not an interrogation, nor were questions being asked to him or to his mother. He never confessed to committing the crime. He, in fact, stated that he was wearing body armor because he feared that people were trying to kill him, and to his mother that he was wearing body armor because he feared for his life. And in fact, the defendant also stated that the possession of body armor is no charge, and the police were holding him to protect him. In that way, the defendant admitted to, one, the possession element, but not to all of the elements of the crime. Appellee makes the statement that the parties stipulated to the fact that the defendant had a prior conviction for a violent felony. But a stipulation between the parties doesn't affect the way the people, or any of the parties, I should say, use evidence. You evaluate the statement or the admission or even a confession at the time that the statement was made. It is not bound, an examination or an evaluation of the applicability of the corpus delicti rule is not defined by stipulations that are agreed to at trial. It is determined by the statement at the time that it is made.
Counsel, going back to your alternate theory of why this evidence, or this question was asked and why this evidence was presented, you said it was the foundation for the admission of the evidence of the body armor?
Well, for twofold. Number one, it was definitely admitted, Your Honor, to show that the item that Officer Stockwell took from the Canadian officer and then gave to the Port Huron, the local police officer, was the same item, which is something that we're required to do under MRE 901. But
So there's some chain of custody, but there has to be some connection to this defendant to make it relevant in this case, right?
I agree with that. And the people,
In other words, if it was just like the tire iron from the Canadian officer's car, that wouldn't have, there wouldn't be, the body armor has to have some connection with this defendant, right?
the body armor does have to have a connection to the defendant, and that is why the prosecutor actually argued that if you were to convict the defendant based on the exchange alone, that there would not be enough evidence to convict him. But the defendant made admissions of fact as it relates to possession, but the admissions were not the equivalent of a confession, because if it would have been a confession, the defendant would have said, "Mom, I was wearing body armor and I couldn't do so because it was."
I get
yes?
that. You have some other evidence that the conviction is based upon. I'm trying to understand how that testimony is a proper foundation for admission of the evidence.
Well, we did admit the body armor into evidence at trial. So in order to establish that the item was what it purported to be, it was necessary to...
What did it purport to be?
Body armor, the body armor that was recovered or taken from the Canadian authorities. Then it went to the American authorities, and then it went to the Port Huron police officer.
So there's a connection. When the authorities turned over the defendant, they turned over this body armor.
That's right, and his truck, and I think a knife. And again, body armor in and of itself is not illegal.
What I'm trying to understand is how strong is the inference that the body armor is connected with the defendant? And I agree with you, that evidence alone would not be sufficient to convict the defendant.
Right.
But the more you need to make that connection for it to become a foundation for admission of the evidence, aren't you making your opposing counsel's argument that the natural inference is that this body armor, the Canadian authorities, when they arrested this defendant, he had possession of this body armor?
I think viewed objectively in the totality of the circumstances, I actually think that the most reasonable and most logical inference that the jury drew was that the defendant was the person that jumped the toll, because that's how it was framed. The trial prosecutor was very careful because Justice Viviano, as you know...
But he must have had this body armor either on his person or in his truck or somewhere if they're turning it over at the same time, right?
Could you please repeat that?
There must have been some connection with the body armor either on his person or in his vehicle, or else why would the authorities turn it over at the same time, right?
I would agree with that, I would agree with that. And I don't disagree that inferences can be drawn from that specific exchange. And if there was a concern about a jury misusing or jumping or reaching the wrong conclusion or wrong inference, then certainly a limiting instruction could be given. And we are allowed to show the parties direct evidence and circumstantial evidence, so reasonable inferences flowing from the evidence. We're allowed to rely on direct evidence and circumstantial evidence to prove all of the elements of the crime. And also, it was also offered to show the effect on the listener, meaning that it put into context, consistent with People versus Chambers and People versus Putman, to show what happened next, how our local people who ended up charging him with the state crime got involved. So I see that I have exceeded my allotted time, and
We'll save the rest, so.
thank you very much.
Good afternoon, Chief Justice, and may it please the court. My name is Jonathan Sachs from the State Appellate Defender Office for Mr. Washington. I'm joined at council table by Natalie Unger, my colleague at SATO, who's second chairing for Mr. Washington, and by Professor Richard Friedman, who will be arguing separately as amicus. excuse me, on the Confrontation Clause issue on behalf of Mr. Washington. So, to us, this is a pretty simple case. This is a case where there is evidence of a testimonial statement that's provided to the jury, and accordingly, that evidence should have been excluded. And without that evidence, there is no foundation to admit Mr. Washington's confessions. This is not a case where there's a major departure from Confrontation Clause law, straight up application of testimonial evidence, and nor is this a case where it's appropriate in any way to re-examine what has been 150 plus years of corpus precedent in the state of Michigan. It simply is, as the Court of Appeals did, an application of basic corpus law. So with that, our request is either to find that leave was improvidently granted or to issue a similar opinion to the Court of Appeals that this is a testimonial statement that should have been excluded and that as far as the corpus goes, there's no foundation for the confession. With that, I will waive the rest of my free fire zone and answer any questions.
The inference to be drawn from the evidence is pretty weak in this case, isn't it? Should that matter to us?
Absolutely. I mean, Justice Viviano, your question to appellant goes right to the heart of the matter, and that is there needs to be enough evidence for there to be some sort of foundation for the possession offense in order for the confessions to come in. And what we have here is a situation where Officer Stockwell says, look, I arrested him based on these communications. So in other words, Officer Stockwell is saying that he didn't have probable cause to arrest absent what the other officer told him. That's the only foundation here that shows a crime has been committed. And the absence of that probable cause certainly tells us there's not a preponderance of evidence for a finding of corpus such that the confessions come in. So absolutely, the lack of evidence here.
I mean, just the implied statement. I'm trying to reconcile what counsel just said, that it can provide the foundation for the admission of the evidence when it doesn't really tell us the idea that the Canadian officers, who were not very neighborly, right? They don't come and testify. We wouldn't have this case if they had.
Right.
I hope we're better neighbors than they are, but I just can't understand why they can't bother to come over, across the bridge. But the question is, the officers turn over the defendant and body armor. It could be anything, right? The defendant and a gun, the defendant and some evidence. Is that enough of a connection? I mean, you couldn't put that in front of the jury and get a conviction on possession, could you? Because there would be no testimony about where the body armor was, whether it was in the trunk, or whether it was on his person, or anything at all. We don't know anything at this point, right? All we know is when he's turned over with the body armor.
I mean, exactly. That's what we have here. What results in the conviction is it's more than that. It's communication, and based on that communication, he was taken into custody. Justice Viviano, you just expressed what should have been the trial here, which is there's no evidence of the communication. There is no evidence of what happens based on the communication, and then that's correct. There's no evidence. This could be a situation where at the end of every shift, the Canadian officer walks across the border and this is a wrongdoer who did something, and here's some evidence from earlier in the day, or here's the body armor I forgot to give you yesterday. As far as the jury knows, any of those scenarios are what could have happened until we have that impermissible testimonial evidence, which is communications were provided, and based on those communications, when he handed over the body armor, I took him into custody. Without that, you're correct. There's no evidence that links him to the body armor, and therefore those confessions.
I mean, we have the later hearsay evidence, I guess, that's being contested, but I'm just trying to understand in a confrontation clause case if the evidence that's being contested, and then here we have this implied evidence or whatever we're calling it, is so weak how does that factor into the confrontation clause analysis? I know there's a back-end argument that it was harmless and so forth, and that implicates all the other issues about the corpus delicti and all that, but I'm just trying to focus on the confrontation clause on the front end. Is there a point at which the evidence is so weak that it doesn't offend the constitutional prohibition?
Well, is a testimonial evidence for the purpose of a conviction. And in this case, I'd argue that it's actually not so weak. It is distinct communication that is made as the vest is handed over and as Mr. Washington is handed over, and then it's the additional piece where Officer Stockwell says, based on that communication, I took him into custody. So it's not a sort of nothing evidence of no moment. It's actually the key evidence that ties him to the bulletproof vest. Without that evidence, it's something totally separate. It could even be Officer Lavers saying, hey, we've been trying this sort of bulletproof vest on our side of the border. Maybe you guys want to check it out. But what ties Mr. Washington to the bulletproof vest is the statement from Officer Stockwell, based on these communications, I took him into custody. And that's actually not weak evidence at all. It's really strong evidence, and then it becomes even stronger because it becomes the only foundation for these confessions that otherwise should not have been in evidence.
Okay. I'm the only one asking questions this late in the day. Huh?
I do appreciate the timing of the argument. I think with that, I wanted to make sure to make the point about the lack of foundation and the point that Officer Stockwell lacked even probable cause here, and basically admits that when he says, based on these communications, that's what I did. That's why these two confessions shouldn't have come in. I think it's important to make the point and to look at the Porter case and distinguish that these are actually confessions. These aren't statements where he's saying he didn't possess the bulletproof vest. The Porter case is a case where an explanation for an accidental arson is given. That's why it's a statement of fact, not a confession. Here, it's a very basic confession. That was my bulletproof vest. And sure, he makes a self-serving statement there when he elaborates, but it's absolutely the confession that he was in possession. So it is a confession. It's not a statement of fact. I'm not going to touch on the invitation to overrule corpus delicti. That was barely briefed. It wasn't a question this court asked, and it goes against precedent from 150 years now. I'd ask the court simply to find that it is a testimonial statement, as almost every other circuit and state court that we find have in this sort of situation, and to find that if that testimonial statement is excluded, then there's absolutely no foundation for the two confessions. Thank you.
Thank you.
Good afternoon, and may it please the court. I'm Richard Friedman, appearing as amicus. I've been obsessing about the confrontation right for more than 30 years, so I'm grateful to the court for giving me a little bit of time to talk about it. I agree with counsel for appellee that this case does not call for any change of law, certainly not any kind of fundamental change as the people suggest. I'd like to make three main points. First, Stockwell's testimony conveyed the substance of Lavers's statement, so that poses the confrontation issue. And the substance of the statement clearly, it was inferable that what Lavers said was that Washington was in possession of the body armor. And
does it matter how weak that inference is?
I don't think so. I mean, I think that it's readily inferable by the jury that that's what Lavers said. And given that Lavers said something to the effect that Washington was possessing the armor, it's readily inferable given that the testimony is based on that communication. What did you do? I took Washington and the custody and
I mean,
the
in
armor
every
into
criminal
custody.
case, the defendant's taken into.
I'm sorry.
In every criminal case, the defendant's taken into custody, and the jury's usually told that, and so that's not it doesn't necessarily distinguish this case. What I'm trying to understand is there could be a range of inferences, right? There could be, possession is very specific under Michigan law. There's some connection between the defendant and the body armor, but what connection that is far from clear from this brief testimony, right? It could be that the defendant was arrested or turned over and the body armor was in the trunk of his vehicle. Maybe that wouldn't be enough to establish possession unless we could show, the prosecutor could show that he knew it was there, for example. There's different, it's not like, that's why when I think of the evidence, in terms of convicting this defendant, of possession, it's pretty weak, isn't it?
Well, it's certainly not as strong as the prosecution would have liked. They would have liked to have had Lavers. I think this is different from most cases because the key is that the question was, based on that communication, what did you do? I took the body armor into custody. So the strong, reasonable, at least plausible inference, and I think you have to allow for plausible inferences, is that Lavers said he had the body armor to some extent constituting possession. And I think it's clear, but I want to make sure that it's understood that this is not what's been called implied assertion cases. That's a misleading term, as I suggest in my brief. Here, Lavers made a statement. It's clear that Lavers made a statement, and if it weren't clear from Stockwell's testimony, it's clear from later reports, as indicated both in Mr. Washington's brief and in mine. He made a statement. The testimony about what that statement was not explicit, but many cases have said you don't have to have explicit testimony about what a hearsay or an out-of-court statement is to raise either a hearsay question or a confrontation question. Okay, the statement was presented for the truth of what it asserted. I don't think that there was any substantial need to explain Stockwell's behavior. It wasn't presented in that way. It wasn't argued in that way. There was no limiting instruction given. And the people suggest that there's no substantial difference between what the situation would have been if they hadn't talked about the communication or not. There's all the difference in the world. What you're adding is the fact of Lavers' statement. That's the key point. I think the court thought that if we didn't actually say what Lavers' statement was, it's okay. But it was the clear implication. And the statement was testimonial. Okay, I think the governing standard here is indicated by the Fackelman case. Was there an anticipation that it would be used as evidence? Now, sure, I mean, Lavers, maybe he thought he was going to testify, but I think the question has to be, are you providing evidence for possible use in prosecution that if it's allowed? We have to be concerned about the system that we're creating. If this is allowed, then we have a system in which one officer can talk to another officer and create evidence for use in court. And that's creating a system of out-of-court testimony, which is precisely what the Confrontation Clause was meant to prevent. And, okay, maybe Lavers didn't know the possession of the body armor by Mr. Washington was a crime, but this is not an ordinary case of toll jumping. You have a caravan of 3 cars, vehicles coming over with something like 6 officers, and they declined to arrest him in Canada, even though he'd gotten into an altercation with them, handing him over to another half dozen officers on the American side. They clearly think that something significant is up. Whether possession of the body armor was in itself criminal or not, which maybe they thought it might be, it certainly is relevant evidence to anything that's likely to happen. I want to add also, I'm not sure about neighborliness, but there's no real indication in the record that the people made as vigorous an attempt as they should have to try to get Lavers' testimony. They tried. The indication is that they were told by the Canadian authorities Friday before the trial began on Monday that he wasn't going to come. No indication of letters rogatory, no indication of an attempt to use the State Department. The Canadian Supreme Court, for neighborliness, has said that they would look with favor on American requests. So I'm not sure that they tried very hard. I have other points, but I'm happy to answer.
They
Yeah.
should have resorted to the Hague Convention. Huh?
I mean,
They should have resorted to the Hague Convention.
I think the Hague Convention only applies to civil cases,
Oh,
but
it
I that's my understanding. But there are options if they wanted to.
Thank you. I think your time is up, and I don't see any other questions. Thank you for being here.
Thank you so much.
Although I feel like I shouldn't have to comment on the speculative assumptions that were just made, I just want to note for the record that there were vigorous attempts to secure the attendance of the Canadian officer. And obviously, if we would have, we wouldn't be here today. So, number one, this was not a testimonial statement that was given. And the fact that there are multiple inferences that can be drawn, I think is, and then labeling one as compared to another testimonial is exactly what makes the implied testimonial hearsay rule so dangerous. Because number one, we have to decide if it's testimonial. The appellee says that we need to look at objectively the circumstances, which is true, but under Ohio versus Clark, we also have to look at the primary purpose of the conversation, that it was to create an out-of-court substitute for trial testimony. There's no way, under any circumstances, that could be viewed objectively that the exchange and the fact that a prosecutor asked a question based on those communications, did you take him to custody, could then be all of a sudden made into a testimonial statement, believing that he would somehow testify at trial at a later date. Again, the possession of body armor is not in and of itself illegal, and this, although I heard appellee state several times that this was a confession, it clearly was not a confession. It was an admission of fact, and it's no different than other possessory crimes that this court has viewed in the past. So if the court has any questions for me, I'd be happy to ask them or answer them.
I don't see any. Thank you.
Thank you
all.
very much.
The case will be submitted, and the court will be adjourned until tomorrow morning at 9:30.
Thank you very much.